session that Linda is going to educate us about justice in early America. The last one is next month. This one should have been in November, but due to circumstances beyond her control, a little virus prevented her from doing it in November when it was originally scheduled. So the last session will be in January. So, Linda, take it away.
All right. Thank you. Okay, we don't do the slides yet. Whoever's doing the slides, I'll call for them. Okay, so my apologies for getting COVID, but So today's trial sets up the remaining large-scale issues that we'll be dealing with. This issue, which will be race, racism, fugitive slaves, will be done in two sets, two separate trials. And I'm starting with this particular one because it raises an interesting question about emancipation, which has not really been fully addressed in the literature, and I'm surprised that it hasn't. Well, anyway, we're going to address it. And that is, why did emancipation take until 1865, when we had the elimination of the slave trade in England in 1807, in America in 1808. We had in 1777, Vermont abolished slavery. Pennsylvania had a gradual abolition act passed in 1780, which took them 45 years to actually emancipate everybody. And Massachusetts entirely abolished the slaves in 1783. So we have this trajectory, we have this movement forward. And then we get to the Constitution, and the Constitution in 1787 doesn't even refer to slaves, it refers to other persons in order to distinguish them, in quotes, from Indians, citizens, those bound to service, indentured peoples, and persons. So the only references to slaves is this euphemism, such persons, all other persons, etc. So we have to wait through all this time period, and the gradual abolition in Pennsylvania is one of the test cases for whether this country will be able to stand full emancipation. And what we find in this case are going to be two self-emancipated slaves who come north to Philadelphia, and they meet up with an urban crime scene that has been complicated by an underclass that is unemployed. That would be immigrants, that would be fugitive slaves, and that would be the gradually emancipated slaves in Pennsylvania as a result of the 1780 Act. This case will take place in 1808, the year of the abolition of the slave trade. They will meet up in Philadelphia with segregated living patterns that are related to this migration, these migrations. And they will be isolated in an area of the city that is identified with lifestyle crimes and social immorality. Dancing, drinking, loose living is how that is defined. And it's a haven for hit and run crime. At the same time, we have a colonization movement that is beginning. And it's initially supported by Black middle-class community leaders and among abolitionists, with the idea that we will found a country in Western Africa that will receive the freed people who emigrate there. So in other words, the idea initially was that the freed slaves would emigrate. There was never any real preparation made for them to assimilate and to integrate. As I said, the Black community leaders initially accepted this as a solution in order to get to emancipation. What happened was a rise in crime in the urban areas was so distressing that even committed abolitionists started to sour on the idea of emancipation. The black community changed its mind as well and decided that they earned the right to live in America. And so they no longer supported this colonization movement, that their sweat and their labor had created this burgeoning economy. So there was this real, switch. So as a result of this experience, emancipation was delayed until finally a war had to be fought in order to accomplish it. So that's the thesis that I'm working on, and that's why I wanted to start with the John Joyce, Peter Mathias case, because it's a test case for full emancipation following the cessation of the slave trade. You can put the slide up, Costa, if it's Costa or Richard. First slide. There's only 3 slides, but I wanted to follow 3 themes. One will be spatial geography, one will be the cultural narrative, and the third will be the legal issues. And we haven't thought about how to do research by virtue of geography, geographical analysis. So this is going to give us the opportunity to do it. Now, I appreciate that that is going to be very hard for you to see street names and so on, right? And I know that this is not a brilliant solution, but it is a solution. I think it's a solution. No, don't do that. Why are you doing that? Oh, here I am. Okay, can you see this little jiggle-jaggle? That's Market Street. Those are the sheds for markets, literally. Here's the Delaware River. This is Front Street going down here. Right here is going to be where that red line is. That's Blackwell Alley, which is going to be the site of, Black Horse Alley, right here. And right here is Letitia Court, which was the home of the daughter of William Penn. So this is a pretty rich area. Now this is all downtown Philadelphia, and down here is Spruce Street. Below it, but not on the map, will be Cedar, and Cedar Ward, which is where the black community is restricted to living. Segregation had already taken hold by 1811 in Philadelphia. This is 4th Street, and this is 6th. What? Did I go off? You can't really see. There's 6th Street down there. Okay, so this is the white area. Blacks used to live integrated with whites in this area prior to 1811 because they lived in the households of the whites that they served. With gradual emancipation, they started to be liberated, and so they were cast all the way down below Cedar, and so that it was from Cedar to south, below South Fitzwater, from 4th to 8th was the ghetto, and up here was the white area. So this is the beginning of blacks getting out from under the influence, moral and social, of their white, in quote, masters, but they were ghettoized in the process, and there was now no longer any communication between the 2 races of any substance, other than that employable blacks will come up from the South and then go back home, and blacks, the criminal blacks, will come up from below, hit and run crime, and return home. What wasn't appreciated was that there was a very moral and social movement among the black elites, and there was a vibrant black middle class that had also been pushed out of the white areas and were building cultural and educational and benevolent institutions in their community. And in fact, this group, which was led by Richard Allen and by Absalom Jones, originally were members of the Methodist Church in this area. They went up, they prayed on the main floor with the Methodists, but when the Methodists, St. George's Church, renovated, they told them they had to pray upstairs, and as they were praying upstairs, the elders of the church came up and asked them to leave and never to come back. And they said, "Can we not even finish praying?" And they said, no. They did finish praying, they wouldn't leave. Subsequently, they discovered a barn, they put it on wheels, and they wheeled it to an empty lot in this area, and it became one of the earliest black churches in the country. And it was called, it's a long name, it's the Bethel Methodist Episcopalian African American Church. I didn't get that in the right order. 1793, it was founded by this group that was cast out of St. George's Methodist, and it was supported by white elites, among them Benjamin Rush. And in order to honor the foundation of this church on wagons that they plotted in the middle of the white community, the white elite sat at tables and were served by the blacks. They got up when they were finished, they changed places, and Benjamin Rush and the white elites served the black elites. It was it's a wonderful moment in history, and that church, which is still extant, is a example of that. Okay, so next. The cultural narrative. We did the spatial narrative, the geographical one. The public narrative about crime and about race is really biblical, and biblical in the sense that it actually arose from the Bible. So God can see all, as I'm telling this iconic narrative. The hidden will be revealed, murder will out, like the blood of Abel crying for vengeance against his brother Cain. Now, in this iconic narrative, the blackness of sin signifies the father's curse upon the son who sinned and was blackened. That's the biblical version, right? And the mark of blackness identifies your social position and character, and then you have the chain of being, where those who are blackened are at the bottom and those who are not blackened by the black mark, the whites, are at the top. That was the biblical construction of race theory. So black crime becomes identified as a sign of revolt against one's place in that order. And blackness of the skin was a mark of Cain, which was a sign of criminality. This is the criminalization of the black race, was in the cultural narrative, which has its biblical origins. It becomes part of common law and is identified as such in 1765 in Blackstone's commentary, which is a collation of English common law that was printed in the United States and became the basis of American common law. And the idea being that once the mark of Cain is set, he, the criminal, shall find no refuge, no pardon, and in the courts of judicature, thank you, judicature, and flight and concealment shall not afford protection to shedders of blood. Okay, that's the cultural narrative. You can see how damaging that will be. Now, one would anticipate that the black community would have a problem with this, so that when these criminals, this was a scandalous case, this was a very high profile capital punishment case, and in fact, you couldn't get anywhere near the Oyer Intermine, that's the criminal court of the city and county of Philadelphia when it was tried, because 20,000 people were there and 25,000 people showed up at the execution. So the black community had a lot of problem with this, because the theory of the black elite in the black community was assimilation. that we had earned the right through our labor to become integrated into the new United States. And they were actually unwilling to defend these two accused, the two who will be accused of this murder of a white shopkeeper, because they represented the kind of black, in quotes, who they were not prepared to defend, because their interest was in suppressing the kind of a vice that white groups could use to argue, and now this is their words, that African people were inherently immoral and hence unfit for freedom. So there were no protests at the execution by the black community, although there were 25,000, it was a mixed race crowd of 25,000. And the black elite who attended marched them to the gallows, published a gallows pamphlet that warned other members of their community that these despised criminals were the negative examples of how blacks should behave, and then argued the position for assimilation. So we're not going to get much protest or support from the black communities on the issue of, was this a fair trial or not? Because they actually advised the criminals who were executed that they should not hope for pardon. Pardon was a fallacy, that they should suffer their fate for their evil deed. But there was a lot wrong with this trial, and somebody should have said so. And this is not according to our standards. This is according to the law of the time, and the law that could have been applied in this trial. So let's look at the trial and the crime itself and see what we think. The crime. John Joyce and Peter Mathias, I'll give you who they were so you could see, follow from there, were both born slaves. Joyce joined the Navy, fled his mistress, and hoped that through his service in the Navy, he would gain the right to his own freedom. After he left the Navy, he moved around just as Mathias did, from city to city, many different jobs, many different residences, never stayed anywhere more than 3 months. And in the end, in Philadelphia, when he arrived in Philadelphia, he wound up living with a black woman named Margaret Tucker, which would have been a sign of immorality as far as the white community was concerned. He also had a criminal history for theft of a horse and stealing a watch, which would not work well for him in the trial. Peter Mathias was a follower. John Joyce was more of the instigator. Both of them had a family, a pious family from which they departed. And the whole idea is that whoever wrote their confessions probably manipulated that to include a kind of a religious element, and that would have been Richard Allen, who was the black community leader, who was their amanuensis. He took down their confessions, he shaped their confessions, he published their confessions, and then he used it as a publication to convince other members of the black community that this was not the path to go, and that assimilation was what the blacks needed to do if they wanted to get emancipation. The kind of jobs they both held were rope picker, gardeners, musicians, stable hands, coachmen, seamen, drivers, waiters. Some of them were the kinds of jobs that blacks used to improve themselves and to move out of their communities and to actually become, not move out of their communities, but move up in their communities to become members of the black elite. So they, even as self-emancipated slaves, they had a chance to improve themselves, and they experimented with some of those things, but they turned to a life of crime. At least Joyce did. Mathias became a violinist and used to play at events, but because music, dancing was associated with drinking and lustfulness, his turn into music may not have done well for him in the trial. He was still associated with loose living as a result. So what was the crime of which they were convicted? Well, John Joyce had predetermined a murder plan. He needed money, and he knew of this white shopkeeper's store. She was an older woman, and he thought she would be easy pickings. So he asked Matthias to come along with him because he wanted to go to a Mr. Kennedy's who owed him some money. He was a white for whom Joyce had worked. And Matthias accompanied him, and on the way, Joyce kept feeding him drinks to keep him going. And Matthias keeps trying to beg off and say he wasn't interested. They get to Kennedy's, and he's not there, and so Joyce suggests, well, let's go to Mrs. Cross's shop. That was his intentional way along, and he admitted that in his confession, and the trial didn't change anybody's mind on that, and I think it was they got that part right. Matthias tried to depart. Joyce convinced him to stay with him, and when they get to the shop, finally Matthias walks away. During the time he is away, Joyce kills the shopkeeper. Now, before Matthias returns, which he does return, a young girl, it's dark at night now, it's 7 o'clock at night, but it's dark out. The store is dimly lit. A young girl comes, she looks through the keyhole, this candlelit room with the darkness outside, the dimness inside. She claims to have seen Joyce murder Mrs. Cross and Matthias attending. Well, Matthias wasn't there. Matthias hadn't returned yet. So her testimony then becomes a little bit suspect. She's 13 years old. She's a young girl. She's referred to by the judge in the case as an innocent, perfectly innocent, providential figure who arrived as if she had been sent there by God. This is in his sentencing recommendation. So their willingness to accept her testimony is there. It fits the cultural narrative of a providential revelation of sin. So there's the real prospect here. She is, by the way, the primary witness, and it is on the basis of her testimony, uncorroborated, that these two will be executed. But there's plenty wrong with her testimony, because if she saw a murder through the keyhole in the dark, why did she enter the store? She entered the store. Matthias comes back. He sees her there, and he tries to get her to leave. He grabs her hand, and he tries to sneak her out the window. Joyce stops him. So there's no intent on Matthias's part. There's the effort to depart himself previously. There's the effort to rescue the girl, but Joyce terrorizes him, and he stays. So that's the extent of his crime. Well, he is indicted as an accomplice, where Joyce is indicted as for first-degree murder. The reason why this case is problematic is that the jury decides to convict them both of first-degree murder, and they never really hear evidence as to Matthias being merely an accomplice. So he gets not charged on a different crime for which he's convicted, and so there's room there to consider again, was this a fair trial? Okay, so we know who the perpetrators were, we know what the crime was. Who's going to try the crime? Okay, well, we're going to have as prosecutor Walter Franklin. Walter Franklin, within that year, will become Pennsylvania Attorney General. Who's going to be the judge in this case? Well, let me go back just 1 second to a case, the McManus case in 1798, 10 years before. Basically the same set of facts, except that the people who were accused were white. There were 7 of them. They each got separate trials. And accomplices who were indicted on the charge of being accomplices were convicted only of that crime, and some of them were even determined to be not guilty. But in that trial, which had all of the features of this trial, they had simply the president judge of the county as the judge, president judge of the district. So the fact that this trial chooses Chief Justice of the Pennsylvania Supreme Court, William Tillman, to preside should suggest something about the determination on the part of the government to convict these two figures. Again, they're black, the people in McManus were white, the accused in McManus, and also the public importance of the case. They had to get they felt they had to get a conviction here because of the racial breakdown of the city, the ghettoizing of the black community, the bad relations, the rise in black crime, gradual emancipation, and the migration problems of fugitive slaves from the South. All right, who were the counsel? Well, under common law and under statutory law at this time, they weren't, even though it was a capital case, they weren't guaranteed counsel. But Tillman had a reputation for being a stickler, meticulously attentive to the law, and he used his discretion to assign them counsel. Counsel were the brother of Benjamin Rush, Richard Rush, and Nicholas Biddle, from a well-known family. So far, so good. Unfortunately, one is 22 years old, the other is 23 years old, and they have no trial experience. So good on Tillman that he assigned them counsel, not so good the counsel that he assigned them. In fact, the trial report of this case describes them only in these few words, quote, members of the bar just of legal age. Interestingly, they had apprenticed for the law with William Lewis, who was a prominent Philadelphia lawyer who was respected for his work in abolition cases and in treason cases. But they were much too young to carry the burden of this trial. In fact, they called no witnesses. In fact, they never contested the prosecution's evidence. They never petitioned to have the accused testify. It was a problematic defense. And so they admitted the case and then asked for mitigation of the sentence. And we'll see whether that was the best of all possible strategies. With regard to Tillman as a judge, and my final comments on him, he was a slave owner. But he was a slave owner because of his dedication to the law, who followed the provisions of the 1780 Gradual Abolition Act to the letter. If a slave had not been properly registered under that act, he freed them on the basis of that technicality, and he did so frequently. Unfortunately, with fugitive slaves, he was not so amenable. In fact, his judgments on those cases were so irregular that the state had to pass an act in 1820, the Act to Prevent Kidnapping Act, because of a case that he adjudicated improperly. And so they had to pass a state law to prevent the kidnapping of free blacks and their rendition to the South, where they were then thereafter enslaved. So he's a mixed picture. I mean, he has a big reputation, but we're not sure what we're going to get out of him. In fact, what we get out of him is kind of a lot of moral piety, and as I said, his sentencing recommendation where he refers to the witness as a providential act of God makes his performance rather problematic. So we can go now to the law. We talked about the culture, we talked about the geography. I've introduced you to the crime and to the perpetrators and to the people who will adjudicate the case. And I'll just check time. Okay, we're doing well. This witness was a child. And under the law, a child is not the best witness. In fact, she was in category with slaves, felons, spouses, and interested parties as among those who were likely to lie or unable to appreciate the importance of swearing an oath. So the use of a child witness as your primary witness required corroboration by a second witness. If a capital crime required corroboration by a second witness. No petition was ever made for corroboration by the defense, and no provision or acknowledgement of this requirement under common law, as well as under statutory law, was made by the judge. This is the third time now we're finding some reason to object to the fairness of this case, and always, and certainly for Matthias, because he was, after all, he had the better case after all as a mere accomplice. Okay, so there was a two-witness rule for the capital crimes that was not observed. What about had the defense counsel had the accused testify? They could have, first of all, he did not cross-examine the prosecution witnesses, which is problematic, but perfectly predictable, because in order to do so, he would have to have one of the two accused testify. Let's assume he could have gotten them to testify. I'll explain why he couldn't have. You bring Matthias on, who has the better case of the two, and he is going to have to challenge the validity of a 13-year-old white girl. And the moral, think of the morality of that. She is now going to be accused of being a perjurer, and then on the moral side, she has violated her oath to God, right? So that would not go well in front of a white jury. They didn't call Matthias to testify. Could they have called Matthias to testify? No, they couldn't have, because not until 1885 were blacks given the right to fully testify on their own behalf as defendants and swear an oath. It doesn't do you much good if you testify without swearing an oath, but your accuser has sworn an oath to tell the truth and has sworn the oath to God. So for that reason, a number of defendants didn't testify. The other part of why they wouldn't have testified has to do with the fact that they were accused of a crime, and they would have needed some corroboration for their testimony to make it. Certainly, Matthias, if he was to have testified, his only corroboration would be Joyce, and Joyce was himself already a convicted criminal for two other crimes, so that wouldn't have worked. Okay, so it looks like there were going to be a lot of problems for the defense counsel. What about bringing in witnesses on behalf of other witnesses, on behalf of the accused? Well, the most common use of witnesses was to testify to one's character and reputation. Well, all of their witnesses came from Cedar Ward, which was the haven for hit-and-run crime and was considered a ghetto for the black community. So that already was going to prejudice them in the eyes of a white jury. Two of the witnesses that could have testified for them had actually, there were suspicions that they were themselves accomplices in the theft ring that was related to their crime. They were off the boards. Two others had been solicited for sex by Joyce, the perpetrator. That didn't look too good. And another was, had hidden Matthias when he was escaping from the posse comitatus that was sent after them. Immediately after the crime, the people of the neighborhood called a constable, and they convened an ad hoc coroner's jury right there and then in the presence of multiple witnesses and tons of curious onlookers, and declared them guilty by virtue of the coroner's jury. And then they called up what they called a hue and a cry. You just call out, and anybody who is an official or semi-official status can create a posse, and then you can go after the accused. And that's the way in which they were ultimately caught. I forgot why I introduced that. Well, in any case. Was there room in the evidence for me to claim that in terms of evidentiary standards, they weren't given a fair trial? Well, there are two standards. There's violent presumption and probable presumption. Now, in the McManus case, where the accomplices got separate trials and were charged only as accomplices, and many of them were let go because they didn't meet the standards under the law for the crimes for which they were accused, violent presumption was the standard for the evidence. In other words, the evidence presented must necessarily conclude to the establishment of the fact at the same time that it excludes all and every other way of accounting for it. And that was the standard in McManus. You would have assumed that such a standard would be applied here, because in the judge in McManus, Judge Henry, had actually said using the probable presumption standard is uncertain and fallible, and he wouldn't use it for a comparable crime. So as a precedent, that case suggests that Judge Truman should have used the higher standard, the harder standard to meet, which would be give more rights to the defense. In fact, he used the lower standard, so that's a problem in the law. Didn't get a separate trial, got convicted not on that for which he was indicted, but on another charge for which he was never charged. Let's see, separately. There was no consideration of the reasonable doubt standard and no consideration of the presumption of innocence standard by the judge in this case. And you might say, well, those are modern conceptions, I'm thinking backwards. In fact, both standards, guilty beyond a reasonable doubt, presumed innocent until proven guilty, those two standards go all the way back to Roman law. They show up in medieval scholastic theology. They are incorporated and spelled out in the Magna Carta. They become a part of statutory English law, from which we borrow, in the 17th century, 1695. In 1765, they appear in Blackstone's commentary, which is used as the basis of American common law. So by the 18th century, you cannot say that Justice William Tillman, Chief Justice of the Pennsylvania Supreme Court, was not familiar with either standard as to apply them. Well, they were not applied. So I'm going to just introduce one more contention, and that is that an accomplice is expected to have an intent, to have aided and to have counseled in the crime. And we do not have evidence of that in the facts as I relayed them to you. So any way I look at it, I'm finding there are some problems with this case with regard to its fairness, certainly in terms of Matthias's legal rights. And the last piece that I want to introduce to you is the requirements of the 1780 Gradual Abolition Act, under which this trial, in the context of which this trial was held, it allowed, actually it required, equal legal rights for slaves and freemen in Pennsylvania, and it guaranteed them, and this is the language, that the crimes of Negro servants and slaves be tried as like those of free men, in like manner as the offenses and crimes of the other inhabitants of this state, and not otherwise. It's a pretty fair and, set prescription. It was, in my view, not followed, certainly not in the case of Matthias. So I can stop a little early today and take questions if you like. Where'd Richard go? There he is. He's going to bring you a microphone. Or he's not.
Well, I can yell.
Fair.
How was the shopkeeper killed?
The testimony of the young girl said that he picked her up by her neck and shook her. She has to be pretty fragile. Right?
Anyone else?
Earlier in your presentation, you referenced the use of oaths. At this time, there was still some Quaker influence, I would have thought, in the judicial system, and the taking of oaths was not accepted by Quakers. I wondered if you had any understanding of why there was this shift to requiring an oath.
Yeah. In 1776, when we had the Revolution, Quaker influence in Pennsylvania took a deep dive. And certainly in the law, because the Quakers had, as we saw in another case that we considered here, because Quakers had relied to a large extent on arbitrations in order to avoid going to courts, in which they had little faith, and they did not think that was the appropriate way to go. Their reputation with regard to, and their influence over courts was minimal by the time we get to 1808. So for that reason, if there had been a Quaker judge, as there was in the case we're going to see in January, and if there had been Quaker advocates for the defense counsel, we would see a different picture. But we don't have that here. Hey, I'm going to get off easy today. Not so punishing. Yeah. Oh, Richard over here, and then back there. I do, okay, while I'm waiting for the question, I advised you in the very beginning of this series that I would be using the word blacks for African Americans, and I would be using the word Indian rather than Algonquin or Iroquois or Delaware or whatever. And I want to reiterate that here. Why I have used that terminology, because in the academic literature we've pretty much given up trying to be politically correct. And some of the people I most admire have just resorted to the more generic terminology, and it's been largely, to a large extent, accepted. Yeah.
Well, here's a nice trivial question. I heard you say hit and run a couple times. So at that time, that referred to somebody just committing a crime and then taking off? I mean, we could still think with cars today.
Well, when I showed the original map, right, the first lecture where I introduced and I showed a lot of slides, I tried to trace Costa, you can go backwards since you have it up. Go to the first slide. Oh, I never said what that was. That's actually Blackwell Alley, and right on the end is 2nd Street, and right on the corner there was the shop. Blackwell? Did I say Blackwell? Black Horse Alley, yeah. Can you go back to the map? Okay. So you'll see how hit and run it was. Yeah, hello. Maybe we're not going to.
I'll get it. I'll get it in just a second.
Okay. In any case, what I'm going to show you is that they started from Cedar Ward, and they went up and over Spruce, and they went all the way to the river, and then they went up Front Street, and then they went past the street, Black Horse Alley, in order in case, no one could trace them or something, and they went somewhere else. Then they came back, they went back down Blackwell Alley, they went past Letitia Court, they went to 2nd Street, and then right there is the shop. And then they didn't go back the same way they came. They went up 2nd Street, They went all the way over to 5th Street, they went all the way down 5th Street. But the way they came was they came up this way, they went all the way over here to Front, they went up Front, they went past where they were going to have the crime. Then they doubled back and they came back down here. Then they went over there and then they came back this way. I'd say that's pretty hit and run. It's not that there wasn't a plan. They actually had strategized, or at least Joyce had strategized how we could handle it. Yeah, Richard?
Yeah.
Oh, back there. We had one back there first, and then we'll come.
At that time, was there a system of appellate courts, and could they have appealed this conviction, or what was the structure at that time?
Yeah. Appellate courts. State legislatures could actually, for a long period of time, and you can't speak generically because all the states have different systems, right? But as a general statement, state legislatures could actually try crimes. So, and the state Supreme Court had God, I forget the term. Anyway, it had the right to both try crimes on the facts and then subsequently act as the appeals court for that very same case using the same judges. It was very corrupt. So no, there wasn't a clear separation, in my understanding, of appeals courts from first triers of facts courts until maybe about 1830 or so. Clear. But they were edging their way towards that. Over here, Richard. So I can see better than you.
They raised their hand higher.
Was there any objection in the press or in any community to what happened? There must have been a lot of people that really knew the law. They were...
The press, as they reported it, and this was tried in the press, right, as well as there was a trial report, semi-official trial report. In the press, there was only one line that said there were no protests or demonstrations. So they didn't seem too anxious, to object to anything in this trial.
I was wondering if, it may be hard to know this, I think we tend today to just make it a white-black thing on so many issues. We have class differences. You did mention how the upper class blacks, or reasonably upper class blacks were not estranged, but they were not supportive of the new arrivals, so to speak. Was there any evidence of any differences among Philadelphians based on their class or their occupations? Was there who among the white folks would be most, let's just say, sympathetic towards blacks?
Abolitionists,
Yeah.
Quakers. But there's a good book about Philadelphia on this very issue. Sorry, I can't think of the author right offhand. Who takes up that issue of white perceptions of blacks in Philadelphia. And he does through a study of prints of the period. And the prints of the period largely show the black population. They don't make they don't give much play to the middle-class black elite, of which there was a substantial middle-class community, and black leaders were very well respected by the white abolitionists. But in the general cultural scene, the prints that were widely distributed, I mean, you could buy them for pennies on the street, you know, were of blacks who had their own holidays. They had their own July 4th, for example, and they paraded around the streets in these elaborate costumes and bright colors, and they were always accused and attacked for being culturally inappropriate and outrageously loud and all the stereotypes, right? So this is interesting because this is an effort by the lower class part of that community to demonstrate a kind of assimilation, to create holidays that are like white holidays, to dress like the class and the race of which they wished to be a part, but they were totally not accepted. And they were ridiculed widely and with a very sour attitude about it. Yeah, it was a bad period. And remember, they were racially segregated, you know? There was no question about that. Okay. Thanks for sticking with us. Next time you will hear about people who are really defending the blacks and in court. And we will look at some good abolitionist thinking on that regard. Okay, thank you. Oh, yeah, you know, I looked at